You're listening to the Belly Dance Geek Clubhouse at bellydancegeek.com.
Hello, everybody. This is Nadira Jamal from Belly Dance Geek, and welcome to episode 64 of the Belly Dance Geek Clubhouse. This episode is being sponsored by the Belly Dance Bundle, a heavily discounted bundle of amazing belly dance products from dancers around the world. These are all available online to use at your own pace, and I am one of many contributors, and so are several Clubhouse guests. This is going to be coming up in October, but you can sign up for updates at bellydancegeek.com/bundle. So the Belly Dance Geek Clubhouse, the show you're listening to, is a place where dancers can get together and geek out on all of those things that are hard to get in classes and on DVDs. If you want help with the what, things like moves, combos, choreographies, there are a lot of resources out there. But if you want help with the why and the how, musicality, composition, business, ethics, all of that can be harder to find. So every month I interview a different guest expert on a different geeky topic, and we always have time for questions and answers so you can geek out too. So if you think that knowledge and creativity go together like chocolate and peanut butter, you are in the right place. My guest tonight is Galia Aharoni. She's the founding partner of Aharoni Business Law PC in Oakland, California. Galia loves business law because she gets to learn about businesses and industries she would never have learned about otherwise. Plus, this specialty allows her to help other entrepreneurs fulfill their own dreams, something Galia is very passionate about. She's a published author on intellectual property issues and regularly speaks throughout California on a variety of legal and business issues. One of Galia's favorite things about practicing law is the collaborative process of educating people about business and the law so they're empowered to succeed. Galia was a student of Lady Fred's, learning her style of tribal fusion improv, and danced with Fred's troupe, Siren Syndicate. Due to travel, Galia now mostly studies belly dance online, and when not working or belly dancing, Galia can be found coffee shop hopping, reading, hanging out with other people's dogs, and taking long walks and watching sunsets with her fiancé, Mike. You can check her out at aharonibusinesslaw.com. Welcome, Galia.
Thank you so much. I'm so excited to be talking to all of you.
I'm so happy to have you. Well, everybody, Galia is going to be talking about liability for dance teachers. And I believe this is our third episode with a lawyer. So for the folks listening out here, just be aware that this is legal information, not personalized legal advice. Galia, did I cover that properly, or is there anything else you want to say about that?
Yeah, thanks for saying so. Yeah, no, it's information for educational purposes, and one of my goals just in general, and specifically with this, is to just educate people about what they, enough about the law so you know when you need a lawyer and you know when you don't need a lawyer. So if you have questions after this, you can talk to me or talk to another lawyer for specifics, but yeah, just a general thing for information purposes, yeah.
Absolutely. All right, well, before we jump into our topic properly, I would love to hear your origin story. So can you tell us about how you got started in belly dance?
Sure, yeah. So let's see. So one of the things I like to say is that one of my hobbies is to collect hobbies. So I like to just try things for the sake of trying them because I like to try new things. And when I was in college, down in UC Santa Cruz, I took a belly dance class for a few months just because I always thought it would be cool, and I loved it so much. But then I graduated and moved away, and they didn't have classes in New Orleans, which is where I went to law school. So as soon as I was back in the Bay Area, I decided to give it another go, and I found Lady Fred, and I just still loved it. And so I've been dancing with Fred for 5 years or so now. So it's been one of the few hobbies that's stuck because I loved it so much.
Nice. And can you tell us about what interested you in the law or even in liability specifically?
Sure, yeah. So yeah, like you said, I own my own firm now. It was kind of a journey to get there, just testing a bunch of different things and seeing what I was passionate about. I love business law because I get to work with the client to have a common goal and help protect them. And, especially here in the Bay Area, it's really inspiring to be around so many people who have dreams and goals and visions for how they want to make an impact in the world. And so I really love working with small businesses to, a lot of what I do is just protecting them, making sure that they know what they need to know to minimize liability. And so a huge part of what I do is really revolves around liability, because what I like to do is focus on preventing problems instead of trying to solve them after they've already happened, which is sort of the theme of this whole talk today, because it's a lot easier to prevent liability than to try and make it go away after something's already happened. So mostly what I do is work with people to prevent lawsuits, minimize their liability, and hopefully minimize the stress of being a business owner. So to help people protect their businesses and their assets. So.
Cool. All right. Well, the big place to start is, I think we've all heard the word liability, but how would you define that as a lawyer or as a lawyer speaking to an artist or an entrepreneur?
Yeah, good question. So liability, basically, the way that I think about it is, it's kind of a bummer to think about, but if you just sit around and think about what are all of the possible things that can go wrong in the course of your business, and what could people possibly sue you for based on those possible things that can go wrong. So liability is the potential consequences of things going wrong and you potentially getting sued. And so what we try to do is manage or prevent that possible liability. So kind of the two goals here is to avoid lawsuits when possible and minimize the impact of those lawsuits if you do get sued. So yeah, we just try to think about the potential things that can go wrong and how to prevent them before they happen.
Mm-hmm. All right. So I think the context that most people think about this, if at all, most dancers think about this, if they do at all, is in this idea of a liability waiver, right? All of that.
Yeah.
The long or not so long stuff that you usually have to sign. So can you tell us about what a liability waiver is and
sure,
where we tend to encounter those?
Yeah. So, well, and another thing I wanted to add just about liability in general that helps when you think about waivers is that there's sort of different layers of potential liability that can happen because there's different things that can go wrong. So there's the person can do something stupid themselves that, causes them to get injured, or you might make a mistake that causes them to get injured, or or the environment, there's a nail in the floor and somebody accidentally steps on it. And the things that can go wrong are different in each situation. And then the person who can get sued potentially is different depending on what's going on. So a liability waiver is a document that we're going to have your students sign that has terms in it that basically they're agreeing, in a simple words, is they're agreeing not to sue you if certain things go wrong and if they get hurt. And they're agreeing that, hopefully in the waiver, that they understand that what they're doing is there's risk inherent in it and they're going to accept that risk and not blame you for it. So it's not guaranteeing that nobody's going to sue you ever. You can never prevent every lawsuit ever, but it helps us get back to the goals of avoiding lawsuits whenever possible and minimizing the impact if you were to get sued.
All right. And so, who needs a waiver? Is this anybody who teaches under any situation ever? Are there any other situations in which we want that? Who should be thinking about this?
Yeah, I think that, so I'm risk averse. I'm a lawyer. I tend to see the potential problems everywhere. So I think that pretty much anyone who's putting on an event in which any sort of physical activity is involved or there's any sort of bodily injury risk, I think it's always a good idea in that situation to have a waiver because the risk of something going wrong is present. So the terms that we are going to put in are going to be different depending on how risky the activity is. But anytime there's any sort of physical injury risk, I recommend having one. So, it's our dance classes, but it's also yoga classes and Pilates. I know a lot of dance teachers also teach those things. But even, ski instructors, anything like that where there's physical activity going on.
All right. And, what are some of the potential consequences of not having a waiver or having the wrong one for you?
Right. Yeah. So that's, you make a good point. So there's two two potential scenarios. You can have no waiver and you can have a bad waiver. And having a bad waiver, hopefully it covers what you need to cover, but there might be gaps in it where other things can come through. So I'm assuming, first of all, most people who are listening are sole proprietors of their company and they don't have an LLC or a corporation. So assuming people are a sole proprietorship, the way it would generally go, somebody gets hurt, which may or may not be your fault. And then there's some sort of lawsuit, or at least a threat of a lawsuit. You get a phone call from a lawyer or a letter from a lawyer. And the potential things that can happen is, first, you could decide to settle, in which case you'll probably end up at least on the hook for their hospital bills, any actual monetary losses, like if they had to take 2 weeks off of work, you might have to be on the hook for that. You might have to pay their attorney fees. You might have to pay for things like chiropractor or things like that as well. So even if you settle, it still could be a few $1,000s depending on what the damage is. If you end up in court and you lose the case, on top of all that stuff, you might have additional penalties tacked on, which can be really, really big, tens of thousands or hundreds of thousands, depending on the injury. I'm assuming nobody is going to die in a belly dance class, but if something really bad happens, it can be really expensive because they can throw in those penalties too. But also think about, even if you win a case, even if it's kind of frivolous and you end up in court fighting it, you still might be on the hook for $10,000 or so just to pay your own attorney fees and defend yourself, even if you win. So I think, and if you're a sole proprietorship, the person basically is suing you directly, which means they can go after your personal assets, your house, your car, your savings. And if you're married and you have community property, they can then come after your spouse's property too. If you got a college fund going on, all of that stuff, they could theoretically come after. So hopefully it's something small and, you only have to pay a little bit of money to make them better. But worst case scenario, if we get sued, we don't want to see you have to close your business down or file for bankruptcy or lose your college fund. So
don't take this lightly.
Yeah, like I said, I'm programmed to see the worst the worst possible scenario, but it's one of those things where the risk hopefully is low of something really, really bad happening, but you don't want to be in a position where you could have maybe prevented it from happening when it does happen. So yeah, it can be pretty bad. And I did want to also talk about LLCs for a second too, if that's okay.
Sure.
Because I know that most dance teachers are probably sole proprietors, but there are entities like LLCs and corporations that give you what's called limited liability, which means if the company were to get sued for anything, then the person suing the company can only go after the company's assets and can't come after your house and your car and your college fund. And so it sort of gives you an extra shield between the person suing you and your personal stuff. So it does cost money to form and to run and to pay extra taxes for. So if you're running a really small, you're just doing classes once a week and that's kind of all you're doing, it probably is not going to be worth it financially necessarily to form a limited liability company. But if you have a lot of assets to protect, maybe it is. Or if you're running a higher risk company, maybe it is. So that's just another thing to kind of consider if you feel like there's a risk there and you want to protect your assets a little bit more.
Fire dancers, look into that one. All right. So, moving on to, how we start thinking about constructing one of these waivers, what are the ingredients? What should a good liability waiver include or cover?
Yeah. So, again, this is the general bit, because a good liability waiver is going to be tailored to your particular situation. So depending on what you're doing and where it is and what's going on, we're going to have slightly different things in there. But generally, we're going to want to see a few things. The first one is what we call an assumption of risk clause. So all this means really is that there's a sentence in there, a paragraph that says, I, the student, understand that what I'm about to do is physically demanding and it's inherently dangerous. And I understand that, and I am knowingly taking on the risk of injury. and I'm doing it voluntarily anyway, even though I know the risk. So then that they can't turn around and say, I didn't understand that this was a dangerous thing, and therefore, so I got hurt because I didn't know that it was dangerous. So if you have this assumption of risk clause, it shifts the burden to them a little bit. They say, I understand this is dangerous, I'm choosing to do it anyway. The second provision I always look for in these is a waiver for negligence, because negligence, it has to be in writing, basically, to waive away your liability for negligence. So negligence is a term of art, it's a legal term that means a specific thing in the law, and there are variations of negligence. It's kind of in that area where you made a mistake, but it was a mistake you shouldn't have made, right? So let's talk about a landlord. If you're renting a studio space and the landlord hasn't redone the floors in a really long time, and they know it's being used for dancing, and they know that the floors are starting to come up, and there's like a really big nail that's sticking out of the floor, and one of your students gets injured, that's probably negligence on the part of the landlord, because they didn't put the nail there on purpose, but they should have known better. It was their responsibility to keep the floor well done, right? So so other things that could be negligence are, maybe you have you did something that was too advanced for a basics class, and you didn't explain it well enough, and somebody might get hurt, something like that. Hopefully you wouldn't get in trouble for, but it's sort of in that range of mistake, but maybe you should have known better. So that's what negligence is. And so we want to make sure that negligence is in there, because we assume that, you guys aren't doing wrong things on purpose. And if people are doing things on purpose, then they probably should get in trouble for it and should be on the hook. But you don't want to be on the hook for making mistakes. And so we want to put a provision in there that says that they're waiving their right to sue you, basically, for negligence as well, and not just, not just accidents and things like that. So we just want to see terms in there that are really, really clear that they are releasing you of claims, and that they've read the document, they've understand it, they are signing it voluntarily. If you want, you can also put in provisions about personal property, like we are waiving any claims for, theft or damage of our property, if you feel like that's appropriate. Sometimes for people like dance teachers, I'll put things in there saying that they understand and are aware of their own physical limitations, and that they promise not to exceed their own physical limitations. And you can even put in a sentence that says, we recommend you consult with your doctor before engaging in this physical activity. So again, they don't come in with a bum knee that you don't know about, and you have them do something that you didn't know would hurt them. It kind of shifts the burden back to them. So we want to see them signing all of these as a condition of taking the class. So we want to have them sign it before they take the class. And also we're going to want to put in the last thing, that they're over 18 years old, because you need to be over 18 in order to sign a contract.
And now I have had teenage students, and do you want to say what you'd recommend in that situation?
Yeah, so what I do with dance teachers who work with teenagers and stuff is just have a separate waiver. We have the parents sign the waiver instead of the student. So we'll just have the same language in there about assumption of risk and negligence, but we'll add language that they're the parent or the guardian of the student, and that they consent to the student participating, and that they, the parent or guardian, are over 18.
Got it.
So
excellent.
Yeah. So I usually just have one of each.
And do you have any different recommendations for, depending on where the class is held, whether it's at your home or a studio or another kind of space?
Yeah, it does depend on where you're doing it, and this kind of goes back to the layers of liability again. Generally, it is more about the activity than the location of the activity, but you have more liability at a space that you own. than a space that you don't own. So if you have a home studio or you're putting on classes in a space that you own, you have more responsibilities. Now you're the one who's responsible for keeping the floor, well taken care of, and for, keeping it well, just you're in charge of the space as well as the activity. So you need to protect yourself more because there's more possible things that you personally could be on the hook for. If you're teaching in a studio that you're renting out, you might have a little bit less liability because you may or may not be responsible for injuries caused by the space itself, which, by the way, is another thing to look at. If you have a lease, check out the lease and see if there's a provision in there that says whether you are taking, they might be trying to shift some of the blame to you, but you want to make sure that whatever contract you have with your landlord says that you, the teacher, are not responsible for injuries caused by the space itself. So again, we kind of just go back to looking at what the possible things are that could go wrong and who would be responsible for those things. So depending on where you're teaching, it might just affect who's responsible for things going wrong. Oh, and then also another one is that I think a lot of people don't think about is driving. So if you have a troupe and they're your students still, and you all drive to a show together, and you get in an accident and people get hurt, you could also be on the hook because it's, you're a teacher driving your students around and on a group teaching event, and they might be able to sue you if they get hurt in the car. So there's also provisions we can put in if you're doing things like driving that do the same thing, that waive liability or minimize liability for things like car accidents if you're going to be driving people around.
Cool. Now, my guess is that most belly dance teachers are working for themselves, but I am aware of a couple of dance schools where folks come in teaching classes that are offered by the school itself. What do you recommend waiver-wise in that situation?
Yeah.
Or what are some of the liability differences?
Right. Yeah. So again, it kind of goes back to who's responsible if something goes wrong. So yeah, obviously, if you work for yourself, you're the one who's responsible. So having a waiver is super important because you're the one who's going to be on the hook. If you're an employee, it kind of depends. Most of the liability probably will be on the employer, but there's always buts. If it could be if it's something like negligence on your part, you could still be on the hook. And if there's a contract that says otherwise, you could still be on the hook. So if you have an employment contract with your employer, there might be a term in there that says that you're going to indemnify them. You're going to, hold them harmless. You're going to take the blame, basically, for things that happen in your class. It's possible that a contract like that exists. So make sure that, so again, this is kind of general. It's different depending on the facts of your situation. But generally speaking, you'll have probably less liability if you work for somebody as an employee, but there's still risk there. Another thing to note is that, if you work for an employer and you're an employee, your employer might not even want you to do your own waiver because they're the ones in control of how you're running your classes. So they might, hopefully you can convince them to do like a large waiver for every class if that's something that they're willing to do, but they might not even let you do a separate one for yourself. That also does remind me, another thing that's probably worth mentioning is I bet a lot of people aren't just straight up employees for a studio, but they are considered an independent contractor instead. Because I think a lot of dance studios, but also just a lot of like yoga studios and Pilates and health and wellness kind of studios use independent contractors instead of employees. So if you're a contractor, you're basically working for yourself still, even though you're contracting for the studio. But under the law, a lot of the time, situations like that, you the government would consider you an employee under the law and might say that you have been misclassified. This kind of gets in the weeds a little bit, but it can just make liability really confusing if you thought you were a contractor, but then somebody gets sued, and then it turns into this fight about whether you're a contractor or an employee, and then the liability can become really confusing about who's to blame. So it's another thing to just look into if you're a contractor, of just like it's of whether under the law you might actually be considered an employee, because that's going to affect your potential liability.
Mm-hmm. And I'm blanking on the name of it, but the IRS actually has some really good guidelines on that for tax purposes.
Yeah.
They have a checklist of, if this is true about your job or that's true about your job.
Right. Yeah. So the annoying thing is that every agency has its own test for independent contractor status. The IRS is a good one. It's called the 20-factor test, but there's only, I think, like 11 factors now or something, or 12 factors. But California just came out with a new law, a new case called Dynamics that made it really, really difficult actually to be a contractor in California. They want to classify everybody as employees now. So I just wanted to bring it up because I'm doing a ton of work right now about that, about, people think they're contractors, and then this new case came out and probably a lot of people are now employees without realizing it.
Cool. All right. So, if somebody is saying, oh, no, I need a waiver and I don't have one, where should they start? Should they be looking for templates? Should they start with a lawyer?
Yeah, I think it's, it's case by case depending on what you need and what your budget is. I know that, we're small businesses and not everybody has a lawyer in their budget, and that's totally fine. So if you can't go straight to a lawyer, there are plenty of templates online, and I know a lot of people just, borrow them from their friends who are also teachers and just try to update it. I would say the main thing, if you're getting a template somewhere, is at least try to update it and make it as tailored to you as you possibly can, because these waivers are only as good as they are tailored to you. And of course, you can just have a lawyer do it as well, and hopefully it's a good lawyer and they'll make sure to tailor it to you and have all those provisions in there that we talked about. But you could also, if you want to get one online, you can also just try to make it yourself and then bring it to a lawyer to review, which is something that we also do. I do need to say that sometimes it ends up being more expensive to review a document that someone brings to me than to just make one, because you don't always know what they're bringing in the door, and sometimes it's harder to fix it than to just make one from scratch that I know is good from the beginning. So beware of that if you're trying to do it yourself. But just know that if you use a template online, it's probably not going to be specific to dancing and to you and to what you do. But if you can't afford a lawyer right now, at least just try to get a few samples from places online that you trust, and see if you can get some samples from your friends, and just try and tailor it as much as you can to yourself.
Great. And is there any way that you'd recommend for looking for templates? For example, I think there's the NOLO series that has a whole bunch of kind of boilerplate text. Is there anything like that you think is a good place to start?
Yeah, NOLO is one of the only template companies that I actually recommend. I'm really wary of places like LegalZoom and Rocket Lawyer, because they're kind of just like one size fits all, and I just have a lot of people in my office that end up with problems that could have been avoided if they had just gotten something tailored from LegalZoom. So I'm a little bit wary of LegalZoom. I haven't read the ones from LegalZoom or Rocket Lawyer, so I don't know for sure how good they are, but they're not going to be tailored to you. NOLO I really like in general, because they have really plain language that's really easy to understand, and they also have really good explanations of everything that goes along with it. So, they have really good books, I think, for running a small business and liability and taxes and all of those things. And they're a really good introduction, I think, to this stuff. So, I think without having looked at the NOLO template, I in general have good feelings about NOLO, and I think they're a really good place to start, at least, and then maybe you can look around and do a little extra research about things like assumption of risk and negligence clauses and add some stuff that looks like might be missing.
Well, that leads to my next question, which is, so much of what we see when we sign things as the customer is this really dense legalese that doesn't necessarily, that we don't necessarily understand all the nuances of. So if somebody's putting something together themselves, ideally with a lawyer to at least review it, but, does it have to be in legalese, or can you just write things out in plain language?
Yeah, that's a really good question. So it's sort of like a yes, both kind of thing, where it is really good to have plain language. We want to make sure that people know what they're signing. First of all, just because that's the right thing to do, but also it protects us because they can't then, say, no, this waiver I signed is useless, so they didn't even know what I was signing. So we do want simple language. We want them to understand what's in there. And of course, it's us as consumers too. Like, it's really annoying to not be able to read the thing that you have to sign. But the caveat to that is there are words that mean a particular thing in the law, like the ones we talked about. Assumption of risk means something in particular. Negligence means something in particular. So that's why it's good to have a lawyer look at it at least, because it's easy to accidentally change the meaning of words that have legal meanings, specific legal meanings, if you're trying to use super plain language. So I do think it's generally good to have plain language, but we do want to just make sure that we're capturing all of the situations we're trying to capture in there and not accidentally missing something. So again, yeah, it is probably a good idea if you wanted to draft something yourself and then maybe have a lawyer look at it just to make sure nothing's accidentally missing.
That's how I've done most of my stuff, actually. So my lawyer is a big fan of write it yourself and I'll review it. And we've done pretty well in there with templates, et cetera. So, but that is something that did happen to me, is I did misuse some words.
Interesting.
And so, we haven't had to use any of those yet, knock on wood, but that was something that she caught for me. So I'm glad you brought that up.
That's great. Yeah. It's a fine line because, as a lawyer, I want to simplify it as much as possible. I don't want to have, a 30-page document that I'm sending to somebody, but sometimes, a contract, not a waiver, we try to keep them to less than a page at least, but, a contract that I wish could be 2 pages ends up being really long because we don't want to miss anything. So it is that fine line. With these, it's, they're fairly simple. It's just saying, I'm assuming the risk, I understand it's dangerous, I'm waiving the stuff, so you don't have to put in a bunch of extra stuff in there. And like you said, hopefully we never have to use it. But it is easy to accidentally change something without realizing it, and that's what the lawyers are for.
Mm-hmm. Actually, your previous comment reminds me of something. So, one of the big things that I learned in, when I was, studying business to build this business, was that, people don't read everything in detail, right? Yeah. If you're making a sales page, you need a lot of bullet points, you need a lot of pictures, right? Because people are not going to read every word that you write. And so, I think that, especially when you get into the boilerplate templates, sometimes they just have a ton of all of the stuff in them. Obviously, for people to read it, it's better for it to be short. But how do you find the right balance between not making it so long that people don't read it or claim that they shouldn't have had to read it, and make sure that you cover what you need?
Totally. I think it depends on the situation. The more risk there is, maybe the more stuff we're going to want to put in there. And it's also, the likely injuries are going to be really small. Like maybe somebody sprains their ankle or cuts their foot or pulls something, and that's probably going to be the worst of what's going to happen. And so the risk isn't super huge. And so I'm comfortable having a shorter thing that people are more likely to sign and more likely to understand, because we also don't want them to walk up to your class and you hand them this 5-page document and you say you can't dance until you sign this thing. I'd be like, well, no, what are you making? What is about to happen that I have to sign this 5-page long thing? but the more complex things get, the more stuff we're going to want to put in there. If you're putting on a week-long retreat workshop that people are staying at, and you're providing food and all of that extra stuff, then we're going to want to make it longer, because the risk gets higher and higher. So that's what I would say. It's kind of a balancing act, depending on what's going on, and yeah, exactly like what you said. It's more important in these situations to have them actually sign it and understand what's in there, because that's going to protect you more in the long run.
All right, so let's say somebody's got their waiver. Ideally, their lawyers looked it over. If not, they got a good template. What are the options for collecting those? How do you get and manage the signatures on that?
Yeah, this is a little bit less of a legal issue than just a whatever works for you kind of thing. I think that a lot of the teachers that I've worked with or just gone to their classes just have a stack of them sitting in the door, and when you collect the money, you just hand them the paper, and they have to sign it before they can dance. What I like to do in those situations is, they walk in the door, they sign the thing. You can just take out your phone and scan a copy right then and stick it in your Google Drive or whatever, your Dropbox, so you have a digital copy right then, and you have a backup of them. Some people do like to do, if you let people do prepayment online, or you have people book their spot in class online, you can totally get an electronic signature online in advance too. Sometimes physical activity classes will do the kind of check the box online thing. Those are, I feel a little less comfortable with those, because I think it's more likely they're not going to read it. Like I'm a lawyer, and I still don't read the things that you check the box and you just scroll through and click through, so you can go do the thing you want to do online. So if you did get sued, it would be a little bit harder to defend, because although they clicked it, they might have a stronger argument that there was no expectation that they would actually read the thing. So it's better than nothing to have a check the box online. But I recommend having a single page document with one signature for every single person. And they can just sign it when they walk in the door. But again, the more important thing is that you get them. So whatever system works for you that kind of keeps the flow of checking people in the best for you, and all of that is fine. Better to, whatever is going to help you actually do it is the way that you should do it.
All right, and in terms of record keeping, how long do you need these? Do you need to keep them, after somebody's left your class, or for how long?
Yeah, that's going to depend on your jurisdiction. So depending on what happens, you've probably all heard the term statute of limitations. It just means that after you get hurt, there's a certain period of time that you're allowed to sue for that thing. And after that, you can't sue for it anymore. You give up your right to sue for it. So different states are going to have, and maybe even different cities, depending, are going to have different lengths of time that you're allowed to sue for that thing. And also it depends on the injury. So most states are going to be around 2 years so that people can sue. Sometimes it's 1, sometimes it's 3, but it's usually around a few years for small injuries like, sprained ankles and broken bones, things like that. Bigger injuries might have a longer statute of limitations, but you're probably going to have heard about them and know to hang on to the waiver. So I think it's good practice to hold on to them for at least 3 years. But again, if you make a practice of just scanning it and putting it in your files, you can kind of it's a lot easier to just hang on to them indefinitely, and maybe you can shred the physical copies after a couple of years, but you'll at least have an electronic backup if you need it.
Right. And what are some of the biggest mistakes that teachers make when it comes to waivers? What should people be watching out for?
Well, I think the biggest one that I see is just not having them at all. Or I know a lot of teachers actually who had one drafted and totally have it in their files somewhere, but they're not using it because it feels like a hassle. You want to get people in the door, you want to just take the money and start dancing, and it just feels like it is a burden. It adds an extra step. It's more admin work to do to get them, and it's kind of and it's an awkward thing. I'm not gonna let you dance until you give me money and sign this thing. So I do see a lot of people who totally have them in a file somewhere and just don't use it. I did have a client who was using one but wasn't really keeping good enough records. So the way that they were doing it, it was a boot camp, actually, exercise boot camp. And so they had the language up at the top of the page and had like 10 or 15 just signature lines at the bottom of the page. And so it was better than nothing. It was good that they were collecting signatures, but it was just a jumble of unreadable signatures and dates from all over. They would sometimes, one of them's not full, and then they change the pages, and this one's half full, and then, and so if a year goes by and somebody sues, it's going to be impossible to find the person's signature, and it's going to be really hard to defend yourself. So what I recommend is having a single paper with, one sheet for one signature. Make sure they spell out their name on it clearly, and if you're going to be digitally saving it to or actually a full printed folder too, like paper folder, have them organized by maybe name and date. Like you can have it per year perhaps, or in alphabetical order. So if something happens, you can find it more quickly, or if you need to go check if you have one from somebody, you can find it really quickly. So the other main one is probably just getting a one-size-fits-all and not having it tailored to you, because a lot of the time we will see, usually it's the negligence provision we don't see in there, or don't have a special one for minors, and we just want to make sure that your bases are covered. And with all of this legal stuff, the business law stuff, so much of it is just not knowing what you don't know, and it's really easy to make mistakes because you just don't know what you should be doing. And so so one size fits all is just, we just want to make sure that you're not accidentally missing something. So and I think the last one is just is really common for people to think that they don't need one at all because they have, I work for an employer, or the venue, has them sign something, so I don't have to, or I have insurance, so I don't need to get one because it'll be covered, or, nothing's ever happened before, so why do I need one? Because clearly nothing's going to go wrong again. So, for this, I just, like to go back to the goals of avoiding lawsuits and minimizing the hit if you do get sued, because it's really about avoiding things that could happen. And you never know what could happen. Hopefully nothing will happen and you never need it, but it's better to have one and not need it than need one and not have it.
All right. So you mentioned insurance. Can you tell us about liability insurance for dance teachers?
Sure. Yeah. So hopefully everybody already has insurance. I'm assuming that most people hopefully do. So liability insurance is gonna protect you. Well, it's gonna help you cover your costs if somebody does get hurt and sues you. So a good insurance policy will help you pay for the lawsuit and the injuries that the person sustained. What it won't do is limit the lawsuits to begin with. It won't minimize the risk of getting sued in the first place. And so it protects you with the money stuff, but another risk is that even if you have insurance, it might not cover the whole injury, or it might not cover it at all. The insurance companies they're not really out to protect us, they're out to make money. And so if they can find a way to not cover you, they'll find a way to not cover you. So insurance is great, and everybody should definitely have it because it's going to help you if something does go wrong. There are lots of ways to protect yourself as a teacher. So we want to make sure that we're using as many of those ways to protect yourself as possible. So insurance alone might not always cover it. It's not going to prevent lawsuits, and we don't want to be in a situation where you're covered for X amount of $100,000, but it's $200,000 and you have to pay for the rest of it. Plus, even if it is covered, your rates are going to go up, and that sucks. And if you had a waiver, maybe you could have avoided the claim to begin with, which is better than having to to pay out the insurance stuff in the end. And again, just as we're talking about kind of the different shields that can happen, the liability insurance is one of the shields. The negligence waiver is another shield, and the potential limited liability company is a different shield. And they all sort of do complementary but different things. So with all of them, you're pretty well protected. So, if you don't want waivers and you don't want limited liability, at least get insurance if you're going to do one out of all of them.
Okay. So, just to kind of summarize to make sure that, we're all clear on that, when you talk about the three shields, so it sounds like the point of the waiver is to make it less likely that people will sue you and less likely for them to win if they try. The purpose of the insurance is to defray the costs if you do get sued, regardless, and that may or may not cover legal expenses and or what you have to pay to the person. And the LLC's purpose is to limit what you have to pay to the business's assets rather than your personal ones. Is that correct?
Exactly. Yeah. Well done. So the limited liability is going to protect your personal assets. Yeah. So only the business is on the hook for any expenses that you do have to cover, which hopefully at that point would be none. But yeah.
We all hope so. Yeah. Well, that's my next question about insurances. How much coverage do you need? I mean, I don't know that any of these numbers that we hear about. I do have insurance, and they give you this whole table of do you pay this much to have this much coverage, and it's not really clear what's needed.
Yeah, that's a tough spot because obviously the more coverage you get, the more expensive it's going to be, and you don't want to be paying all the money you're making on insurance. It kind of goes back again to what you're doing and the situation. So if you're teaching at your home and you're self-employed and you're doing, big group classes, or you're doing some riskier things, or you're working with large quantity of people, the risk of something going wrong is probably greater. So maybe in that case, we're going to want a little more. If you're employed or you're just a contractor and you're, doing one class a week at someone else's studio and they are going to cover anything wrong with the space, then maybe you can take out a little bit less. So it's kind of going to depend a lot on your particular situation. And it depends on the injuries. I think if we're doing, rock climbing or something that's life-threatening, I would say at least $1 million because somebody could die, and that's what's going to cover it for someone who's going to die. I cannot imagine a situation in which somebody dies in a belly dance class and it's the teacher's fault. Not that it's totally impossible. I'm sure freak things can happen, but I don't think it's unreasonable to not have a giant policy. Because again, like we were talking about, the most common things are going to be like sprained ankles and things like that. So yeah, it's hard to give numbers because it really depends on what exactly you're doing and where and when. So what I would recommend is just trying to find and the other factor too is just risk tolerance. A lot of this goes back to just what you're comfortable with. Some people are like, I don't have any assets and I'm barely doing anything that's risky at all, but I just can't handle any risk at all. So I will do whatever it takes to make sure that I'm not going to get sued and that they can't come after my house. But some people are like, you know what? It's been fine so far. I'm, do my best and everybody seems to like me and I think it's going to be okay. So let's just see what happens. And that's fine too. So you need to just also be aware of your own risk tolerance and what will happen if maybe you have the lower end of insurance and somebody does get hurt, how are you going to handle that? So yeah, the main thing I would recommend is try to get an insurance broker that will tell you the truth. I think a lot of them have an incentive to try and upsell you, and a lot of them, they have that reputation for just trying to sell you insurance you don't actually need. But there are definitely good insurance brokers out there who will tell you, listen, you don't need this kind of insurance, or you only need this much coverage. So that's the best straightforward advice I can give on this is, I can't give you particular numbers, but if you can find a broker who will tell you the truth, I think that'll be your biggest asset in the insurance game. and they'll tell you, you need general liability insurance, or you also need, if you're driving people around a lot, maybe you should also get some special car insurance, and or no, you don't need that at all. And it might also be worth looking into what insurance, if you're renting a studio space, look into what insurance your studio space has and figure out if it does cover you and to what extent it would cover you. Because you don't want to be in the position where you think that it's covered and it won't be, and then you're on the hook yourself.
Okay, well, you talked about general liability insurance. Are there any other particular types that might be on offer or that we should consider getting? Or any particular, I don't know what the right word is, facets is coming to mind, but that's not what I want. Any elements that you want to look for in your policy? Like, for example, would some cover legal costs and others not in the event that you get sued?
Yeah, you would have to probably get extra insurance to cover legal costs. I would say that probably actually isn't usually worth it in your situations with just small businesses and, pretty small risk. So that is an option, but it'll probably cost more. So considering the relatively low risk of injury and lawsuit, I would say, it's up to you, of course. It goes back to risk tolerance, but you're probably not going to need things like that. But I would at least look at really good general liability insurance, and that's going to be different also if you have a home studio or you're teaching classes off-site at other people's houses or offices, not just a studio. The types of insurance for that are going to be different. You're definitely going to want to make sure that if you have a home studio, you're very, very well protected because people are coming into your house. And the insurance coverage might be different if it's at your house versus if it's at a place of business.
If somebody slips on the ice on the way in.
Yeah, exactly. And yeah, also just like automobile insurance too, if you're driving with people in the car.
All right. And, how do you find reputable insurance? What should you be looking for as you evaluate options?
Yeah, I think that's a good one to do, word of mouth. I know a couple that I really like and trust. So if you want referrals for stuff like that, we're always happy to send referrals for people like that. But yeah, asking around, honestly, I think is the best way to do it. It's really hard to tell if somebody's good based on their website or even necessarily Yelp reviews and stuff. So I would just ask around your dance community and see if anybody has a person that they really trust. And give them a shot and talk to a few of them first and see who you feel comfortable with, and don't work with anybody that you don't feel comfortable with, who you feel like they're not telling you the truth or you can't be fully yourself with. And because that's I sort of consider an insurance broker as part of your business team, and it's hopefully somebody you can work with over time and trust to go to with questions, and they should be trying to help keep your rates low and get you the minimum amount of insurance that's going to get you the coverage you need. So yeah, ask around and kind of just go with your gut on that one. But I'm happy to send referrals too if anybody wants any.
Thanks. All right. Well, we are getting close to the end of the call, so we're going to start taking questions and answers for guests pretty soon.
Okay. Great.
But if people take one thing away from this call, what would you want that to be?
Yeah, I think that the one thing would be what I say to a lot of my clients about business law in general. It's easier and cheaper and faster to prevent problems than to try to solve them once they've happened. So I think it's worth a little bit of effort and maybe a little bit of money to get the waivers now and to use them to save yourself from potential lawsuit later. Because like I said, better to have it and not need it than need it and not have it, because it's a huge bummer to have someone in my office that has a problem that could have been avoided by having a waiver or having a contract in place. So So with liability waivers specifically, but with, business law and just business planning and running a business in general, easier to prevent the problem than to fix it later. So that's the philosophy I try to live with and try to help my clients with too.
Great. And if people would like to learn more from you, are there any ways for them to do that?
Yeah, so you already mentioned my website earlier, aharonibusinesslaw.com. So you can always go there. We put articles up there all the time, and we put on our own events sometimes, and there is a newsletter sign up on the website. You can also email Juliet, who is also a belly dancer and works with me. So she's at juliet@aharonibusinesslaw.com. She's the person in charge of our newsletter, so you can always just say, put me on the newsletter, and she'll put you on there. We're also on Facebook and Instagram and YouTube and all of the things. So if you just Google my name, it's probably the easiest way to find it, because I know my last name is a hard one. So but getting on the newsletter, we put it out just once a month. We put events on there. We put articles about laws that have been changing and things like that, and also just useful articles that we think people would benefit from. So that's probably a way to do it. If you do want to talk to me more about your specific situation, I'm happy to book meetings with you too and give everybody discounts for working with us if they want to. So you can just contact Juliet or contact us through our website, and we can set a meeting up and just let us know that you came from the Geek Club, Belly Dance Geek Clubhouse, and we'll make sure to give you a little discount.
That's awesome. And are you limited to any particular geographic areas? Do folks have to be in California or the U.S.?
Yeah. So I am licensed in California. The waivers I would be doing would be California based. So that is true. But I'm also happy to find referrals for other states as well if people need recommendations of lawyers in other places. I can see what I can do.
Awesome. Thank you so much.
Yeah.
All right, so we are going to open this up for questions and answers. So if you have any questions for Galia, we would love to hear from you. To do that, if you are just listening on the webcast and don't have your mic and phone or your computer's mic and speakers hooked up, you can use the question box on the right. That looks like a little rectangular bubble with 3 dots in it, and you can type in a question. If you are on the phone, Skype, or have your mic and speakers connected, you can press ** to unmute yourself. Actually, I misspoke. If you're on the phone or Skype, use **. If you're listening with your mic and speakers, I think you can use the little unmute icon over your name on the webcast. We would love to hear your questions, or if you have a favorite takeaway or a funny or just funny in hindsight legal story, we would love to hear those too. So please don't be shy.
I have a question.
Mm-hmm. Looks like this is Treasure.
Hi. Was wondering if you have anything that you think might need to be addressed if you're teaching specialized groups of students. For instance, I work with very young children. I have a friend that works with special needs, both children and adults. And I'm considering teaching a class in a senior center that would be specially built around people who have low endurance and low mobility. Is there anything that I would need to really, really consider over and above what you would put into something for just the average class?
Yeah, it again kind of depends on exactly what you'll be doing and who each of the people are going to be. I think that I would probably recommend having some extra language in there about capacity and physical limitations. We had mentioned a little bit about, having a little bit in there saying that they're acknowledging the limitations of their ability, but you can even go so far as to have them agree in writing or maybe even initial that they acknowledge that they are of the physical, they have the physical capacity to participate in the activity, and if you need to, you can even require, proof from a medical doctor or something like that if it's really sort of in the extreme. But I think there's just some extra language in there that you can put in either as the parent acknowledging that they understand, that they acknowledge the physical, whatever limitations of the student, or in the case of the, if you're doing it at a senior center, some extra language saying that they are well aware of their physical limitations, and they promise that they are not doing anything that they know is outside of their physical limitations, and that the responsibility is on them to stop doing it if they know it's beyond their physical limitations, and that you recommend that they talk to a doctor before they engage in the activity.
Got it. Okay, great. That's great information.
Yeah.
All right, thank you.
Great.
Tell me how I mute myself.
Oh, I can mute you again, Treasure.
Okay,
I've
great.
actually got a little bit of a follow-up on that one, too, is,
Okay.
obviously in the kids situation, you have the parents sign it for them. If you're working, seniors tend to be pretty capable overall, but if, I don't know what Treasure's situation is, but if she was working with like very elderly seniors, would there be any question as to whether they could sign for themselves?
It could be, yeah. That kind of gets into murky legal waters where, because you don't want to be in a position where you have to be making a decision about whether they're competent to sign a legal document. So I think it's safe to assume that if you're at a senior center or, an organized event, that they have the cognitive capacity to sign. But you can use your gut too if it seems like they're not quite able to understand what's going on. If there's any doubt in your mind, then that's an opportunity to maybe say, hey, maybe I should check with somebody before I let this person sign, because it's also questionable whether that person should be participating to begin with, because if they're not with it enough to understand the document, then it's more likely that they'll be injured because they might not be able to follow your directions as well. So it's kind of a twofold risk there. So I'd say if there's any doubt in your mind, try to talk to somebody who might know, and maybe not have them participate until you get confirmation.
Cool. And I just kind of want to reiterate that I'm not knocking seniors here. I have a 78-year-old student who is sharp as a tack and wonderful in class.
Yeah.
I'm just like picturing like a nursing home exercise class situation or something like that, where, it might be folks who may have a little more incapacity than others.
Right, yeah. And so if you're in that situation, presumably there's somebody you could talk to who works there if you have any doubt about somebody's ability. Yeah.
Cool. All right. Would anybody else like to ask a question or share a story? We would love to hear from you. This is the part where we wait.
Hopefully I didn't scare everybody too much.
The legal stuff is scary sometimes, but, I think it's kind of like the how to exit the plane drills. It's scary when you think about how it actually works, but it almost never comes up.
Yeah, it's true. It's true. Better to be prepared.
Exactly. All right. Well, I think we're going to call it there. Thank you so much, Galia.
Yeah, thank you so much for having me. It was really nice, and I'm glad to have found out about this group. I'll be a participant in the future, so I'm looking forward to that.
Awesome. I'd like to give another thanks to our sponsor, the Belly Dance Bundle. So if you want to get the latest updates on this very heavily discounted bundle of online belly dance products, and then this year we're submitting the Improvisation Toolkit video series, you want to sign up for information at bellydancegeek.com/bundle. And to let you know what's going on in the Belly Dance Geek world, we have a little bit of an announcement. So if you have been listening to our sister podcast, More Than Steps, you have heard some episodes from our newest team member, Heather Wayman, and she is going to be co-hosting the Clubhouse with us. So we're hoping to begin that next month, but a lot depends on her schedule. So you are going to hear some more geeky voices. If you're not familiar with Heather, she is a longtime client of Belly Dance Geek. She's been working with me, I want to say, since 2011. And we've been talking for years about having her start to offer some of my coaching programs. So we're super excited to have her officially on the team. and you will get to hear from her very soon. And thank you everybody for coming. This is the end of our call, but the conversation isn't over. We can continue discussing this in our private Facebook group that we have just for the Clubhouse. Now there is a delay, so if you want to join us, we'll send an email shortly that has a link to the group, but you do need to request to join so that we make sure that it stays within the dance community. So sometimes that can take us a couple of days to approve you. The email will also include a link to the call recording if you want to listen to this again, a link to some of the resources that Galia mentioned, and also have a link to our topic survey. So if you have any topics or speakers that you'd like to suggest or any improvements that we can make to the Clubhouse, we would love to hear from you. And also mark your calendars. This is only tentative, but we're hoping to nail it down soon. Our next call is going to be on Tuesday, September 25th, where we're going to be featuring Tiffany Norrell on online learning. And the last thing that I want to say is that this is the come on in kind of Clubhouse, not the no boys allowed kind. So if you know anybody who would like to join us, you can invite them to do that at bellydancegeek.com/clubhouse. And until next time, happy dancing. Good night, everybody.
Thanks for listening. For more geek-tacular resources, visit bellydancegeek.com.